Good morning, everyone. We're just going to give everyone a minute or two to log in. So just hang out for a minute, and then we'll kick things off. Great to see so many faces who are at the first Form I-9 webinar. You're back for more.
Katie and I were joking that there's probably a core contingency that we're just like, she can't possibly have more to say about the I-9s. She went for 90 minutes. There's no way there's another 90 minutes in her.
But there's more.
There's more.
Well, good. Well, it looks like we have got sort of most of the folks who are coming in. We'll have some folks trickle in. No worries, and we'll put some information in the chat. But let me just run through some introductions here. So for those of you who are here in person live today, welcome to our second webinar in a 4-part series on immigration topics for employers. Today we are building off of last week's presentation, and we're today going beyond the basics of the I-9 form. So before we get started, I'm going to talk a little bit about housekeeping for this meeting. So all of our participants are in listen-only mode. Yes, this meeting is being recorded. We will let you know when it's available for on-demand viewing on our website. We will have all of the videos for all 4 of these webinars available to you. If you have a question for Katie Minervino during this session, or for any of us, put it in the Q&A, which you see at the bottom of your screen. If you're on a desktop or a laptop, time permitting, we will answer questions at the end of the session. There is closed captioning available. If you look at the bottom of your screen, you will see a little box with CC in it. Just click on that and it will show you the captions. If we have any documentation to share or other information to share, look at that Q&A feature as well. That's where we're going to share other useful materials. If you lose your Zoom connection, and we know that it happens sometimes, try the following. Close out of Zoom entirely and come back with the meeting link. Click on that meeting link again. If that really doesn't work, try unplugging and plugging it back in again. And by that, I mean reboot your computer and reconnect with the meeting link. That should get us through most of our housekeeping. And again, for those folks who just came in about a minute ago, yes, we are recording. Yes, you will get the recording because that's always the top question. Our webinar series would not be possible without our wonderful sponsors, AARP Maine, Bangor Savings Bank, Kennebec Savings Bank, MEMIC, Merrill's Investigations and Security, Northeast Delta Dental, and Summit Natural Gas. So right now I'd like to turn it over to Patrick Woodcock, who is our president and CEO, to talk briefly about a new initiative and to introduce our speaker for today. So Patrick, over to you.
Good morning, all. Thank you, Katie, and thank you to our sponsors and all those who are participating in this ongoing series. We did want to provide an additional opportunity on an ongoing effort to successfully integrate immigrants into Maine's workforce. Building on the activities of this webinar series, we have heard from some employers that have had success in providing English language services. We are going to be partnering with Engen in the coming months to provide complimentary English language services to existing employees. This is a service that employers, including Maine Health and Tyson, have had success with, and we wanted to offer this to all members and Maine employers. If you are interested in, we have only opportunities for about 5 or 6 employers at this time. If you are interested in this free service, please contact Mark Ellis, who will be putting his email in the chat. Again, this is something that we've seen some best practices from some of Maine's advanced employers who are integrating immigrants into their workforce and wanted to offer it to all of the main employers who are integrating immigrants into their workforce. With that, I did want to turn to Katie Minervino, who is a partner at Pierce Atwood and leads um, their immigration law practice to build on the discussion of I-9 and move beyond the basics. Katie, I will turn to you.
Super. Thank you, Patrick, and thank you all for who are attending today. Thank you also for those who attended last time. This is intended to be beyond the basics, as Patrick said. Our first presentation focused on some of the kind of fundamentals of the I-9. We talked about the form, we talked about why we did it, we talked about kind of the common issues that can cause discrimination complaints. We talked about a lot of the basics, and this is intended to go beyond that for some of the considerations that you're likely facing as employers that relate to whether you should use an electronic I-9 system, whether you should use the alternate virtual review options. What is E-Verify? What is E-Verify Plus? What questions, feel free to add them. And it is confusing. I mean, kind of like they're not the same. Virtual review is different than electronic, although they're both done electronically. E-Verify is something separate than electronically using the technology available to create and store I-9s. So it's important to have a good grasp of this, because if there's any confusion around it, that could have serious consequences. So for example, if you're using an electronic system and you think you're in E-Verify, that could create a whole other host of issues. So we will start today with a quick I-9 overview and a quick kind of like recap of what we did last time, and just kind of frame this. The whole process starts from the Immigration Reform and Control Act of 1986. It requires employers to verify employment eligibility of their employees. They are not allowed to discriminate based on citizenship or national origin, and you cannot retaliate relating to enforcement of the rules. This process, it applies at point of hire to every employee hired after November 6, 1986, and every employer is covered along with certain entities that recruit or refer for fees. So if you missed the first presentation, I personally think it's really funny to make jokes about how I was born in the early 80s and me and the form are both millennials. We're kind of navigating paper to electronic. I think we'll probably be able to spare you some of those in this presentation. But the core concept is that the I-9 is a tool. It's paper, but it should be thought of as a more dynamic process, because it is the way that employers are required to verify that the people working in the United States have work authorization. So the employers are the gatekeepers who run the first presentation. And it also affords employers really important protection, because if you do the I-9 and you do it correctly, if someone is on your workforce and they are not employment authorized, but they've completed the paperwork, you've done your part, and they just had kind of like a very good fake document, then you are not liable for having the potential penalties for knowingly hiring or continuing to employ an unauthorized worker. So it is very important to do it and to get it right. One of the questions that kind of opened in the Q&A here talks about, when should re-verification of the I-9 documentation occur and when shouldn't it? So the I-9, kind of as a quick recap too of what we're doing and thinking about, and a lot of times it's kind of one and done, when you hire somebody, if you have their identity verified and their employment authorization. But it is in some cases a dynamic and living document and process when people come to you and they are presenting proof of employment authorization that's valid only for a certain time. So you do the re-verification. It's not just kind of kind of set it and forget it in all cases. You do the re-verification if you have somebody that has work authorization for a finite period, and you know that. You know it if they present a document to you at the outset that shows my employment authorization expires on this date because I have given you an employment authorization document that shows it. US citizens do not have employment authorization that expires at a certain date. US citizens, if you complete the form and they have unexpired documents at the point of hire, kind of like that's complete. Lawful permanent residents and asylees and refugees, they're also US workers. You never re-verify the employment authorization on a lawful permanent resident card. If anybody had a question, and even if everybody turns this off right now, if you were doing it, stop. That is discriminatory. You are not permitted to re-verify the employment authorization for an LPR unless they would give you something that would constitute as a receipt, that you needed to follow up on. So that, kind of the core thing is if somebody's work authorization expires in the future, you are required to re-verify them. Kind of the interesting thing, and I'm going to put a pin in this, and this is going to be next, kind of a topic for next week in the seminar, is, kind of, well, what do you do if you have knowledge? Kind of like what is knowledge? What if it's before that expiration date on the card? Do you re-verify at that point because somebody said to you, I'm a TPS worker and my status is ending? What's the interaction for that? And then how, kind of how do you manage this on the front end? The other question in the chat kicking this off was about putting questions about, screening in the employment application. Are you work authorized? Do you require sponsorship? That's, kind of managing the process in the very front end. And, those are, acceptable to put on the application form. We're gonna kind of dig deep into that in next week's presentation. So, today we're talking about the Form I-9, and I put the penalties up again because, the dollar numbers are high, in terms of potential paperwork violation penalties for the Form I-9. Right now, under the current fee schedule, so these would be in place if you were to get a notice of inspection, you had a fine assessment. As of today, your liability and your civil penalties for paperwork violations would range from $288 to $2,861 per form. And that's, that could be potentially a very high number, so that could be, kind of times every form you have if there's something wrong with every form. And there is risk of finding a 100% non-compliance rate by the government, in particular if the employer is working with an electronic I-9 system or vendor that has, some type of deficiency or error that runs to every single form. So if you are working in an electronic I-9 system that has a fundamental problem with it and the government comes in and finds that, that's kind of low-hanging fruit in terms of the government being able to assess a high penalty. So you would be in that range, for all forms times the number of forms created under that system. Or if you're doing something fundamentally wrong, like you are doing a virtual document review, but you haven't met the conditions of doing it. Again, potentially a blanket 100% finding, on every form, regardless of, how the fields were completed. So, it's something that's very important to focus on. And in this advanced session, we're going to talk about, thinking through some of those issues that are beyond just how the form, kind of the form would be completed. And there are, also civil penalties for knowingly hiring, recruiting, referral, or retaining unauthorized aliens. That's the language in the reg. And those can be really high too. The 28,000, that's a, kind of multiple infraction penalty. There are tiers depending on the number of potential violations. But again, kind of your civil liability is high. And there's also potentially criminal penalties for employers who are doing things like harboring workers, kind of like, in the areas that the criminal laws impact. So it is very important to have a focus on this. And, under the current administration, we anticipate and we are seeing higher levels of inspection enforcement. So this is a good time to be focused on these issues and, take corrective action, if and when required and you're able to do so. So the electronic I-9 considerations, what are we talking about? And I did promise I would spare you, my walk through the past in terms of examples when, we've used paper and then we've moved to electronic things. I shared, I think about, kind of the use of photos, thinking about things that I did in paper that my kids, would blow their mind. But, this process was rolled out in the 80s before we had the internet. So we had a paper form. And, if we just think about all of the aspects of our lives, and especially in the employment that have moved to, doing things electronically, it makes sense that there is, kind of like an interest and appetite, kind of like, kind of options to create this process in the form using technology and electronic, kind of solutions relating to the form. So under the regs, an employer is permitted to create and or retain the I-9s electronically. So you can do it. Like it doesn't have to be paper. You can do this. You can do this electronically. And there are specific electronic I-9 regulations that you can find at the site on the PowerPoint. And I would highly encourage everybody to, kind of jot the citation down and then put them in your, kind of your browser, either, kind of like during this presentation if I get boring, or at some point if you have a few minutes, because it's really important to understand what the regs say. If you have an inspection, what is the law? What are the regulatory requirements that you would need to defend your practices in your system against? Fundamentally, regardless of like what vendor you use, what's going on, like what do the regs say? And it's been, frankly, kind of difficult, in practice to kind of get your arms around, kind of whether systems are compliant, if there's risk of being fined, because a few factors are at play. One is the regs are, kind of poorly written in a large, kind of a large way. And that was, kind of in many ways intentional, because the individuals who drafted the regs for electronic I-9, they understood that technology would change, over the course of the years that you would be applying to the rules here. And they wanted to keep the rules and the regs relatively broad so that they didn't quickly become outdated. And there's an example of something that happened within the regular, kind of regs. When you look at them that aren't specifically in the electronic system, it talks about being able to store the forms, and retain them. And it gives you specific examples of how you can do it. And, they talk about like paper, microfiche, or like, these electronic I-9 regs. So you're just like, gosh, like microfiche, go to the library. I don't even know if they still have them, but, again, they're just like, yeah, we don't want this to be, kind of outdated. So they wrote them pretty broad. And, over the years, employers have kind of struggled with how they should be applied. There's been, nationwide inconsistent, approaches to how much, an ICE or HSI officer who reviews the electronic forms and systems, how much they understand it, how much they care, kind of what their level of focus on that electronic compliance is. So, kind of like it's been kind of a patchwork, of compliance or enforcement over the past couple of decades. And, kind of that could result in you using a system that has, successfully or unsuccessfully gone through inspections before and had an issue or not an issue. But that's not to say that if you had an inspection today that you'd have the same results, because the electronic systems and vendors have, adapted and moved forward, depending on kind of like, kind of where they are. So it's, it's a evolving area, and it will continue to be, and that tracks, kind of what we all see in our daily life as technology changes and evolves, and things that we were using platforms for one thing, we might have shifted to another. Platforms develop. If I get one more, like every time I look at my phone and like the app store, there's like 100 things that need to be updated. Things continually change, and that's the world that we're living in. And as I noted in kind of the core consideration, if you have an inspection and the Immigration Customs Enforcement Office of the Department of Homeland Security and the HSI, the Homeland Security Investigations Unit, that would be responsible for doing the I-9 inspection, if they come in and they look at your system, they're going to say like, okay, if you have an electronic system, we want to know about the system. Very, very, very likely your notice of inspection would say, kind of like, we want information about the system. We want information about how it's used. The ICE agent might come on site and ask for a demonstration. They might ask for any like policy manuals you have around it. They want information about the system and kind of like what the employer is using for it. And if there's a problem, again, you might kind of like just get a blanket 100% non-compliance rate because there's something fundamentally wrong with the system that's working in. So it's kind of great in a lot of ways. Electronic systems tend to have lower levels of errors that would be kind of the normal paperwork violations, like somebody forgot to put a number in a field, somebody forgot to kind of like put a date. Those are harder to make in most electronic I-9 systems because they won't let you advance in a lot of systems unless all of the required fields are completed. But you have to, kind of like as a system, show compliance for these minimum performance standards, which are in the regs. And, again, no specific requirements, but, kind of standards in terms of what you'd be looking for if you're thinking about, in this case, record keeping. So the government, if you're keeping the forms electronically, they want to make sure you have a secure database, password protected, that you can index and find the forms, that they can be backed up. And a lot of this, that kind of makes sense. These are important forms, that the government doesn't want to be in a position that they come to do an inspection and the employer's like, oh, weird, like our system crashed, we didn't back them up. Or when you also think about the information on the forms, there's a lot of PII, personal identifiable information. If you are, kind of like, creating the form, if you're not E-Verify, it's optional, but you might be putting your social security number in. You have information like your social security number. If it's you choose to present the social security card as a List C document, like birth dates, like all of the details that are very important for there to be appropriate security, kind of attachments too. So that's a focus on the regs. Another, kind of very significant focus in the electronic I-9 space relates to the requirement that there are audit trails for the forms. And this goes back to, a concept and something that we talked about in a theme that was very strong in our first presentation in terms of the form, needing to be able to track who did what and when in the form. If we have section 1, the requirement is that the employee prepares it. So the employee, unless they're using a kind of somebody who helps them as a preparer or translator, which would be disclosed in the form, it's the employee that's filling in the information, choosing the information, what to put on the fields, choosing, very significantly choosing the box of what type of worker they are. We mentioned briefly in the prior presentation, it's a big deal under immigration laws if you claim to be a U.S. citizen and you're not a U.S. citizen. So the government wants to know who checked that box that said in section 1, I choose I'm a U.S. citizen, or checked, the other boxes and gave the information, who signed the form, where is this information coming from, so the concept of the audit trail, which we're going to talk about in a little bit more detail on a further slide, is basically just like, okay, kind of like we've got this electronic form, you print it out, great, kind of like there's no handwriting on it, it's electronic, it has just like it has data. Where did this come from? Who did what and when? And the regulatory requirement of the audit trail is, kind of in the regs, and it's a very, kind of high level of focus, and it's requested and required if you're using an electronic system to create and store. If you have a notice of inspection, it's something that the government will focus on. Another, kind of another key area which relates to a lot of these concepts is, did your electronic signature, kind of meet the regulatory requirements? The regs are specific in the I-9 space that you can use an electronic signature. However, it has to be attached and affixed, at the time of the transaction. And in the system and in the process, there needs to be a confirmation that the person who's signing is seeing the language that you would see on the paper form if you had it in front of you, that basically says, kind of like, yes, kind of I'm signing off in this language, which includes, kind of a confirmation that they're attesting under penalty of perjury the information in the form. And this, this goes to, kind of why you are, kind of sharing your time with us today. The I-9s, they're kind of a big deal when you think about it, because they are required under law and they are assigned under penalty of perjury. And so the government, they want to be able to, if necessary, prosecute individuals relating to the forms, and these are usually situations that are the really bad actors, people who are, kind of like employers that are kind of abusing workers, they're harboring, they're running, document production factories and not great conditions, like that, kind of the bad actors. But if you're going after them, and you're looking at this from the employee standpoint too, like, okay, who signed it and how do we know? Who did that under penalty of perjury? Like, what's going on? All of this is intended to be able to, kind of, if you think about it from a prosecution standpoint, like create that record and that trail. And, the government they do care about it. These are key aspects of the compliance systems, and ones that are, important to kind of keep top of mind if you're thinking about your system. If you're using it, kind of how do you feel around that, kind of in terms of like knowing what you know about it. And if you're using an electronic system and you don't know what your audit trail looks like, you haven't really sat down and looked at like, kind of what it looks like if the employee signs the form or the employer, this is a good time to do it. And these are, really important concepts to keep in mind also if you're vetting a system. If you're in paper now, you're thinking about going to electronic, or maybe you're, in one electronic system and you might want to go to another one. So for the storage, as you're thinking about it, we touched on some of these, reasonable controls are required under the regs to safeguard the information, reasonable controls to make sure that people, are not, kind of like accessing the forms who are not authorized to do it, looking at the system, having the checks and balances around the signature, and you have to be able to get them, you have to be able to index them and to be able to kind of like create a record that makes sense, and to create these legible and readable hard copies. Because again, you're in the same world if you're using the paper or the electronic one. So if you think about it, when this stuff actually, like, kind of like the rubber hits the road, if you get an inspection notice from the government, you have under the regs 3 days to turn over the forms, and you have to turn over the forms and all of the attachments to the I-9, which are part of the Form I-9 record. So basically, the regs require, like, yeah, gotta be able to turn them, and they have to be able to be indexed and organized and make sense. It's not enough to, get a notice of inspection and then turn over, a jump drive with just a bunch of like, kind of like jumbled information on it and be like, oh yeah, that's what we have. Like the government's like, no, kind of like this has to, this has to make sense. And, one of the things we talked about in the last presentation was like, it's really, this is all intended to, kind of like somewhat begrudgingly from the government standpoint, like allow an electronic process, but one that really fundamentally tracks the paper process. It's really intended to, kind of mirror the paper I-9 process to the extent possible. And as flagged, as we kind of started to dig into this, that if you're getting, kind of an inspection, and kind of where you'd likely see issues on the 100% non-compliance rate would likely really, it's not a guarantee that these would be the only risk factors, but where you really want to focus on the front end is this like electronic signature and the required audit trail. Like, so if you're, kind of, if you're the government, these are two things that you look at on the front end, and these are very important areas of focus. This slide here is, kind of it's a screen grab from what's called the Dinkins memo. So there was a Freedom of Information Act request that was sent to the government in 2012, and the request was, around, any guidance to the field for ICE relating to electronic I-9s. And they issued, kind of a memo. If you Google it, it's pretty redacted, but in unredacted versions, you might be able to find, it contains as an appendix this sample acceptable electronic Form I-9 audit trail. So you can kind of like, this gives a glimpse of what, kind of the government is thinking about when they're thinking about what they'd want to see on the audit trail. So you are, kind of looking at the date stamp, like, who did what and when, kind of date stamp when, kind of like, when did this occur? And that's important also because, they want to know when the form was created, because that's part of compliance. Section 1 is completed by the employee on, or, at the close of business of the first date of employment for hire. Section 2 is completed within 3 business days of the date of hire. But like, when did all this go down? Like, when were we doing this form? Who touched it? Kind of, this has the example of the name, the user ID, and the PIN, and then what did they do? How can we tell? This is, kind of, this is the only information that we have from the government in terms of like what they're thinking about for the audit trail. And the government will not bless any particular vendors, and they will not say like, yes, we vetted this vendor, they're good, we like their audit trail, we like this vendor, we don't like this vendor failed. And their position is just like, because the vendors can change, so they're not going to go and say like, yes, this one vendor is good, and then have something happen and they change their technology and everybody rely on their approval and then have it be a problem. They're basically like, you are going to be liable for whatever was going down at the point that, we inspected it. And, kind of, we're not going to give you any cover by saying this vendor's good or this vendor's bad. Some employers will, look at the electronic system and kind of like think safety in numbers, like if they're using a vendor that has a lot of clients, a big footprint, kind of like you're like, well, kind of like hopeful that this, kind of that signifies that they have their act together. Some vendors will say like, we've been through audits before, we haven't had any issues. That's a positive indicator, but like I said a few minutes ago in the presentation, like it's not the end all. Like you could just have had somebody go through and that particular inspector might not have been as tuned into some of the issues. That doesn't guarantee, kind of future success. So that certainly is, a positive factor in vetting a vendor. And kind of the idea too is just like, all right, like, kind of like this is our standard. It's wild. So, this, like, in thinking through this, like, this is from 2012. So here we are now. We are, kind of like this is going to be turning 13 in August. That's kind of wild too. Like, so our best available guidance in something that's electronically is now 13 years old. A lot of stuff's happened in the past 13 years. But anyway, kind of this is, kind of like this is what if you're vetting somebody and you're looking at the audit trail, you want to see kind of like this as the bare minimum. And, kind of if you think to a flag a couple of things, as you're thinking through it and maybe vetting, one thing that the government, kind of like they can get kind of like concerned about, relating to the audit trail and some of this stuff too, is just like, okay, like, does it show like for sure, kind of like who did it? So things that, kind of like you'd want to be thoughtful around and how you're viewing it is like, okay, who put the information in? And that seems really like obvious. You're just like, well, yeah, it's the employee. They started it. You're like, okay, but did that information, was it entered for the Form I-9 or was it pulled into the form because you're part of a bigger HRIS system? And, I put my data in on an opening screen and it populated like 10 other things my employer needed me to do. Like if possible, if you're vetting the systems, if you can toggle that system off if stuff's auto pulled, or at least, kind of try to make it so that if when it pops up on the form for the system, like they're fillable fields that it could be edited, again, it's that kind of that liability thing. Like, all right, like if I'm giving you my cousin's name and your system didn't have me fill it in, it kind of like the system pulled it, even though arguably I put it in earlier. What does the audit show? I mean, it's again, like, from an employer standpoint, like there's always going to be kind of a balance in terms of like convenience and use of technology in the I-9 and everything else, but this is what the government's thinking about. They're like, okay, like, where did that data come from? Did Katie put it in? Or, kind of like, could she argue if she got in trouble that it was like Katie Clark because Katie Clark like started, like, I mean, it like, that's the kind of stuff that you want to look at for the audit trail. The other thing that they look at, I don't think this is as prevalent nowadays, but like, again, like kind of like looking at it too, like depending on what your system is and like what it looks like, they don't really like the keyboard pass, so like, I'm the employer and I like, fill it in with my keyboard and then I hand it off, to the I say, okay, like, like here, I kicked this off. I logged in here. I'm giving this to you. You do section 1, hit enter, and then give it back to me. That can have issues in terms of like, depending on your, kind of like the way it tracks your computer, like all of those things. So, there's a, kind of, I think, a happy middle ground. I think it's wrong if you have, kind of an auditor and inspector take a look at it and, kind of like take the position that it has to essentially be like a keystroke record of everything that happened in the system. Because if you look at their, kind of their example, that's not what it shows. I think there's room to push back, but you do want to kind of just like take a common sense look at it and say like, okay, like at the end of all of this, like who did what and when? Does my audit trail show it? And, I'm going to, transition in just a minute around, kind of the virtual document review, which is a separate issue, but, a few things that we talked about in the last session too. And I just want to reiterate it, as we're thinking through this. At the end of the day, the government is going to hold employers liable for their forms, and technology is not going to be an excuse. So they don't care. They're just like, kind of like, all right, all employers, kind of like proceed, and use electronic systems at your own risk. So if you have a system and they say like, kind of like it's not good, are there any issues from the government standpoint, that is on the employer, and the employer is who the government will ultimately fine and hold liable for any issues with the electronic system, electronic vendor. Similarly, if the system is set up in a way that, there's a deficiency that doesn't necessarily relate to, kind of the regs in the creation and the storage, but, kind of like, has implications for the forms in terms of, for example, what the employee is able or directed to present for the I-9. Similarly, the employer will be on the hook for any discrimination claims from the employee if the reason that there was a problem stemmed from the technology that was used. Again, technology is not going to be an excuse. So, what do I mean by that? Like, so say I'm completing the form and I check the box that I, kind of am in a, kind of a, and I think they updated it says alien authorized to work, so say I check that box and I, kind of go into the next step and I, kind of like I've checked that box, and as a result of my selection, the options for, kind of like the drop down in section 2 for the documents that might be acceptable have been limited because of the selection I made in section 1 based on what the vendor or the, kind of like the kind of form creator for this technology understood to be applicable options for the category. And then what if they got it wrong? What if I am authorized to work and somebody didn't understand all of the different combinations of documents that might be acceptable? And when I go to present my documents to my employer and they look at it and they say like, oh, this document, which might be valid and kind of authorized, like, I'm sorry, like, you are not able to work because I can't complete section 2 of the I-9. Then I would have a claim, for discrimination because I was work authorized and the employer said no, and it would be a limit of the technology. So in situations, and I think kind of a best practice, what you want to be thinking about is like, okay, like, there might be scenarios that like, kind of like some type of employment authorization has kind of like, developed relatively recently. The government will take this documentation, kind of like maybe there's an issue in the system in terms of like accepting receipts. There's a whole, kind of a whole universe of documentation that can be acceptable for the I-9. And the number, like every like permutation, like it's literally the thousands. Like if you think about how many different identity documents in list B could be acceptable when you're talking about like, kind of like a state issued ID, like, and like there's just like there's lots of documentation. You want to trust the information being presented in your instincts, but you do want to verify it. And if you are in a situation that you determine that you should have somebody working and your technology is not allowing you to do it, then you should just do a paper form. Like if you're doing an electronic form or the system, that does not preclude you from also having, a paper form for a particular employee. And that's what you want to do if otherwise that person couldn't work, even though they should be, because of a limitation in your system. So that's something that, kind of is just important to kind of like always think about and empower yourselves and your team so that you have, kind of the ability to, kind of like keep people working. You don't step into problems because of kind of like a problem with the technology. And the regs are clear, and you can have electronic forms, and it can be a combination of paper or electronic. And that's the case for most employers, because if you have somebody that was hired before the internet, you have a paper form. And if they're still working, you keep it on file. So you might have started with paper and then your company like picked up technology, or you grew, or, whatever, kind of was like, you might have paper forms for longer term employees. You might have your electronic ones for this one, maybe you switched vendors. And again, a very important takeaway is, like, okay, well, if I did change vendors, like, what happens if I get an inspection? Like, do I have access to those forms, that were in my older vendor? Like, can I get that audit trail? Like, like, yikes, like, kind of what happened during that period that we switched, and a lot of the vendors, they'll let you get the information, but I don't think they let you get it forever. Like, so it's really important if you're, kind of like transitioning vendors, you have transitioned, you're thinking about it, to make sure that as part of your exit plan, you're getting what you need from that other vendor, and then you're thinking about, kind of like how you're going to retain it, how at every step in every combination of your documentation, like whatever it looks like, needs to meet the regulatory requirements. Paper is easier in some ways because you're just like, okay, I got my piece of paper. Like, even if I maintain the original. What if at one point you decided to PDF your paper? Like you have to keep the original forms on file. If you kept them and now they're PDF'd, then now the government has said, like, yes, like, you can do it on the condition that you digitalized those paper forms and you are meeting the electronic I-9 retention requirements, with those forms. So, kind of like it's worth, if you do have forms on file that are, stored exclusively as PDFs, to take a look at what that looks like. And if you were asked how that storage and retention complied with the regs, can you show that it has reasonable security methods? Like, I don't know, like, is there an audit trail? Like, what would that look like for that? Like, did you make changes to it? Like, how are we thinking about that? Kind of if it's stored, is it, kind of index, does it meet any indexing requirements? So, again, like a lot of employers have Form I-9s that, as a, kind of like just, kind of like the nature of how they've been, kind of like created, stored, and evolved over the years, is going to have a combination. And that's fine. That's perfectly acceptable under the rules. So I see there's a couple questions that I just going to circle really quick before we transition to document review, still around the re-verification. So one question is, we do not re-verify U.S. citizen or lawful permanent resident. Examples of those who we would re-verify. So there's lots of people that might be working for you that have, kind of temporary work authorization. Sometimes sometimes you don't, at the point of hire. So some employers will sponsor workers. So they'll say, like, I have a particular need, I'm going to sponsor an H-1B worker. That would be somebody that's re-verified. Some people are here and they're eligible to work without employer sponsorship. So if I have an asylum application pending, I'm eligible to get an employment authorization document valid for a finite period of time. If I'm here and I'm going through the green card process, maybe I'm married to a US citizen, or, I have a, process that's going through one of a few other limited means, like, I'm eligible to get an employment authorization document. So there are, kind of like a lot of people that are here in one category or another that are not US workers, but are eligible to work. And those are the ones that you need to sponsor. It's tricky for the lawful permanent residents, because lawful permanent residents get cards that are valid for a finite period of time. And you want to think about that kind of like how your US passport expires also. So for lawful permanent resident, they generally get a card that's valid for 10 years. You don't re-verify at the 10-year period. They do have to go back to the government and kind of get their, like, fingerprints done again, get the newest version of the card, get the picture taken. Lawful permanent residents used to get cards that were green. That's why they're called green cards. And they never expired. And then you'd run into a situation that you had like a child, get this card. And then 40 years later, they're like, here's my lawful permanent resident card. And you're just like, that's a child. So it's like, the idea that, the way I think about it in terms of the 10-year period is you don't reapply for the substantive basis of the green card. You go back and you kind of renew it. And the government wants you to get like a new picture, kind of like fingerprinted again. And then also, kind of get cards that have whatever, kind of like security and like, kind of like, hologram or whatever the current version of the most secure document is. And this is the case too, even if you have somebody who's a lawful permanent resident that the card is valid for only 2 years and it says conditional permanent resident, you still don't re-verify them. That's, kind of on them to remove those conditions. But, for lawful permanent residents, they are US workers. And unless they give you something that the rules tell you, you have to check back in. And typically that's like temporary proof of status. Like, I don't have my card, so I got temporary stamp on my passport. You don't re-verify the work authorization, of US workers. So we're going to talk about virtual review. We're going to, kind of talk about E-Verify in a minute. So there's one more question about, kind of E-Verify. We're going to talk about those workers in a minute. So the virtual document review, is something that is is a relatively new development. So, and it's a post-COVID development. So, when you're thinking about the I-9, like we've talked about, kind of in this presentation and the prior one, the employer is responsible for verifying both the identity and work authorization of the employee, and they are reviewing documentation of the same. The documentation has to be acceptable for I-9 purposes, and the documentation presented needs to be the employee's choice of documents. You don't require a particular document or different documents in the I-9 process. And kind of the statutory language. So from the INA, the Immigration Nationality Act, it requires that the employer for the I-9 makes certain attestations about the status after the examination of documentation that would establish the individual's identity and employment authorization. Okay, you're like, all right, you just said that. Thank you for reading me the INA. That's exactly what you just said. So we've got the statute, and then we've got regs. So you've got the statute, and then kind of the government writes the regulations that kind of like implement, like in practice what the statute means. And the regs for the I-9 say they require an employer or an authorized representative acting on the employer's behalf to physically examine the documentation offered by the employee to establish identity and employment authorization. And that's the legacy language, and that was always, in effect. And kind of the requirement, because this is like, kind of like just as the paper form has evolved, and then we had the possibility of the electronic forms, the whole concept of doing what we're doing now and, kind of like looking at each other on video is not necessarily new, right? Like, so like I think they just retired it, but remember Skype? Like, that was around for a while. Like, the whole video stuff has been around. So for a long time, people were like, all right, why can't we do this on video? Like, like, is there not a different way, especially if you have, workers who are remote workers and they're not coming on site? You could and you still can use an authorized rep for the I-9 process. And I'll talk about that a little bit at the end if we have time. But, kind of everybody was always like, it would be great. It'd be great if we could do this via video. So everybody's just like, yeah, but then the government was like, yes, but the regs say physically examine. And there were like, some creative colleagues that I have on the American Immigration Lawyers Association that was just like, physical means use your eyeballs, and we're using our eyeballs on the virtual review. And I was like, that's really creative. Kind of like, I like it, but it's the way the government always interpreted it was physical means in person. Physical means like in, kind of like seeing each other like in person, like physically present, looking at the documents. And you can understand why the government likes that, because they want to touch the documents. Like they want employers to touch the documents. Like if I'm doing the I-9 for an employee, they want me to sit down and they want me to like hold in my hand, the documentation that are presented. So you can kind of like, you can look at the front, you can look at the back, you can feel it, kind of like, so, there's a higher standard of review for the in-person. That's where we always were. However, a couple years ago, DHS exercised its regulatory authority to, with their rulemaking process, there was notice and comment, they did like the whole thing. And they authorized that there could be an optional alternative to the in-person physical document examination methods employers have to follow as part of the I-9 process and the current regs. So this is like, I think like about like 2 years old at this point, kind of like going back, it kind of dropped in the summer of 2023. So, kind of like happy birthday to happy birthday almost to the virtual review. And it was like, it was a COVID thing. Like I still, had we not had the pandemic, I genuinely don't think that we would have, kind of the possibility of doing the virtual document review. This was a COVID thing, because during the pandemic, when we were in, kind of March 2020, and things were getting like real weird, and like nobody was going anywhere, and we had like, kind of like the kind of all of the like, kind of like the 14-day like flatten the curve, and then it extended, and we were masked and we're all over the place. Like everybody was just like, this is really hard to do the I-9 because we are like really not supposed to be close, and people are not coming into offices. And if we are in offices, like we've got our masks on. So like, and the government was like, okay, like, the government was like, all right. So we are going to, during COVID, they're like, we're going to announce, DHS announced that they were temporarily suspending the requirement for employers to review the work authorization documents in person. So like pause. They weren't like, you never have to do it. They're like, if you're like meeting these conditions and you're like, kind of like not having people on site because of the pandemic, like you can kick the can down the road. And instead of meeting with them in person, we're going to allow you to look at copies of documents. And that was in place in different permutations from March 2020 until this July 2023 date that I just mentioned. So they had this like period that they're like, all right, like, kind of like you don't have to review them in person. But then when they said that the flexibility was not going to be renewed, because they like announced it for a little period of time, and then like so much with the pandemic, like on and on, like, and it's kind of like, and there were different conditions during that period. They were like, all right, at the end of this, that's fine, but we're gonna do something new. This isn't that they didn't just like carry all the COVID stuff directly into it. They're like, done with the COVID, you still have to do it in person. But moving forward, we are going to look at this because like, kind of the world did not stop spinning because we didn't have people, do this documentation review in person. And, from a very practical standpoint, a lot of jobs post-COVID became and stayed remote. So like we have a different workforce where, kind of pre-COVID, most of us were, full-time in the office, and then post-COVID, that's not always the case. So there was an executive order that came through, and it was related to, kind of transforming the experience, of kind of like the US constituents, like, looking to reduce hurdles, minimize, time taxes, think about processes. And what came from that was this concept of like, well, what would it look like if, on a longer term basis, we didn't have to do the I-9 physically in person, kind of like, what would that look like? And so they started, kind of like doing the whole, kind of rulemaking process. And, in response to that, the public came back and they're just like, yes, they're just like, this would be really nice because of telework, because of the challenges for remote hires, which have frankly always been kind of a pain in the I-9 process, accessibility, efficiency, like, isn't it better if we have like a core group of, kind of like people like the ones that are like, kind of going through trainings like this that like get the I-9 process? Isn't it better, for a big company to have like a core HR team that's just real good at it, and that's doing it remotely instead of like having everybody in the field who might do like, kind of a couple or might not do a good job, like, kind of isn't this better? And the government was like, okay, like, like here we are, what we're gonna do is we're gonna write a reg. And what the reg says, it's interesting. So the reg does not say exactly like what needs to be done. The reg says there's an option for the government to allow a non-in-person, kind of process. So in doing that and saying like, yes, we are going to allow an option, the government was like, okay, and then we're also going to tell you right now what your alternative process is. So they announced that kind of separately, but they were also just like, and we're going to revisit it. And, just like, it's an option that we can take away. So I don't know if the, kind of the virtual process will last forever. I think what's going to be kind of telling is, kind of what the current administration, kind of like assesses from some of the kind of the audits that they're doing now for I-9s, especially to the extent that they might be looking at employers, for the first time, because this is still relatively new, that are using the alternate process for the virtual review. Are the I-9s being done correctly under that process? Are they seeing like possibly higher incidences of concern for fraud, or unauthorized workers? Depending on how the future plays out, we may keep our alternate process now. We might lose it. We might have a different optional process, because what the reg says is that we wrote a new reg that says like maybe, and we didn't say exactly what it looks like. We're like, we're going to keep our like, physical inspection, process, but we're going to add an alternative that can be exercised, and, kind of we'll keep the United States updated on it. So what it rolled out when they're just like, yes, maybe, they're like, yes, maybe, and this is what it currently is they rolled out this alternate process. And the way that they did it was they conditioned the use of non-in-person review on, several criteria that the government assessed in thinking through this, gives them the same level of kind of like confidence and security that you would see if you were looking at documentation in person. So again, like, from the government standpoint, like they went there, like, they didn't want it to just be like oh, like, like, yeah, I signed off that like we FaceTimed. You're like, yeah, that's fine. Like, kind of like, on an honor system, like just kind of like looking at it, they're like, no, like, if we're going to do this, like, where do we think we can land that we think that we're getting what we need, and if we're not going to be like touching the documents in person. So they created this, kind of like list of conditions that you have to meet if you want to do the alternate process. And, one of them is that the employers, they need to examine copies of the front and back of the documents, on the front end, so that you look at it, you look at the copies and you kind of like, you troubleshoot on the front end, you troubleshoot the copies. This is one of the problems that, and one of the reasons that we weren't like able to, I think, to just kind of like shift from the COVID stuff to this like longer term process, because during the COVID, they had acceptable like options for the temporary, kind of temporary flexibility that did not involve a live video interaction. So you were able to like fax document copies to do the form, because the whole idea was that at the end of, kind of like whenever like the employer, the employee was no longer taking COVID related precautions, the employer would look at the documents in person. So they're just basically like copies first, like in-person review later. Because of that, kind of like they're just like, no, we like, what if people just sent copies and you never looked at them? We couldn't just transition. So when they thought about it, they're like, what we really need in all cases is the live video interaction. So, kind of if I'm doing this form, I send the copies, to my employer. They have to, kind of like take a look at them. And then we have to do a live video interaction where I present the documents on the screen that I gave the copies of. So I am like, kind of like if we are, kind of doing this, I am like, grabbing my purse, like I'm getting out and I'm grabbing my passport, and I'm putting it up to the camera so that you can see like, my ID document. And then like, kind of you're looking at, you go like, you like, does this match the copies, in this live video? And then because the standard is like, do the documents reasonably appear to be genuine and relate to the individual presenting. So if I send you a document copy that does not look like, kind of like that looks like me, or that looks like what you expect that I'm gonna look like, and then I show up and I look entirely different from the like, kind of, so there's this like, kind of this review of the person that's built into it too. So you do that process, the employer completes the form, and there's a new box on the version of the form that took effect when they rolled this out that says like, I use the alternate process. And then the employer has to keep those documents on copy. So it's, kind of like we talked about in the first presentation that it's generally it's optional to keep copies of documents. If you're an E-Verify employer, you have to keep copies of some documents. But if you are doing this alternate process, like part of your record has to be these documents that were sent to you ahead of time. And then if you have an inspection, you have to kind of turn all of that over. So it's like it's not everybody can do it. It's you have to go through these like additional steps, which they're just like, okay, if we're not going to have people look at them in person, then we at least have to look at them in video, and they should be able to review copies ahead of time. Like, all of this needs to kind of fit together. And it's not for all employers. So you have to be a qualifying employer to use the alternate review process. And one of the conditions is you have to be a participant in good standing in E-Verify. So you have to be an E-Verify employer. So they're basically just like, all right, like we're going to talk in a minute about what E-Verify is, but they're just like, as a condition of using this program, an employer has to be an E-Verify, because that gives you, kind of the additional step of then taking the information on the I-9 and sending it into the system that compares it to federal government databases. And that gives an additional level of, kind of like security to the information presented. Did it pass these checks in the Social Security Administration and the DHS database? So the employers have to be in good standing. They have to be enrolled for all the hiring sites that are using the alternate process. They have to be in compliance with the requirements of the E-Verify program, and that you have to continue to be enrolled in a participant in good standing when the employer is using the alternative process. So you can't just enroll in E-Verify for like one location that you hire people and then unenroll and be like, yeah, we got our number, like we're good. Like you have to be like, this is an ongoing, kind of process that you're doing. And then, there's not really any clear guidance right now in terms of like, well, what does it mean to be good standing? It's not like you don't have proof of it, you don't have a certification, but like you're ineligible if you lack it. So, if you think that you might be in trouble trouble with E-Verify, if you've gotten like calls from E-Verify, if you've got desk visits, if there's some type of compliance record from the employer that suggests that like you might be in a, kind of like a little bit of hot water with E-Verify, kind of you want to be thinking about, kind of whether this alternate review process is for you. So it's, kind of it's what everybody wanted. Like this is what, kind of like a lot of people are just like, yes, kind of like we need this. In practice, my sense is that like, kind of like it hasn't really taken off, to the extent that maybe like people thought that it would initially, because you're still checking boxes, people started to come back, the government, they allow some flexibility relating to it. Like you can use it for some employees, but not others, but you have to do that in a non-discriminatory manner. So you could, for example, say all our remote hires use this alternate process, but for those who are coming on site, they have to do the in-person. That's okay. You just, want to be thoughtful around it. You want to be consistent. If you have somebody that you as the employer, like, let's do this electronically, and they say, I'd prefer to do the regular in person, employers have to allow that. You can't make people do stuff kind of electronically, which is fair. Not everybody has access to technology. People might have certain like, kind of limitations that this is just not a process. And again, you don't want to have somebody, boxed out of working because of something that the employer is opting into, which is optional. And it's, kind of it's important to kind of like think about this in the big picture, because again, if there's a misunderstanding around how, kind of like this alternate review process worked, and you were just like, oh yeah, like I think I can use it, but you're skipping a step. Like maybe you're not in E-Verify, or maybe you're not getting the document copies ahead of time, or there's something kind of like, kind of missing, or you're not keeping the document copies. Again, like if you have an inspection and you don't have all of the pieces together, you could have a 100% non-compliance, finding for all of the forms that were created in a way that were not compliant, like either knowingly or unknowingly. And it's a strict liability standard. Like if you don't get it right, you're going to be fined. And the more instances that you get it wrong, likely the higher the fine assessment you'll see within that range, because you have like really a pattern in practice. It's not a one-off, something, kind of something has been going on for most forms. And the government will look at, from a standpoint of like, all right, like, kind of big picture, like, like should this employer have known better? Are they big? Are they sophisticated? What resources do they have? Like how, kind of how are they doing this? But it is, it's a good option still. And, I mentioned, and I'll touch on it briefly, kind of the remote hire stuff has always been, kind of challenging for employers, because if you happen to hire somebody and they are not coming on site within the first 3 days, like who looks at their documents? Like it's that can be really tricky. And employers can do the I-9 process, in person, if they are using an authorized representative to stand in the shoes of the employer. So you don't, if you're doing kind of like a remote hire and you're not using the alternate virtual option, you have, and you continue to have the option of, kind of like delegating the review from the employer standpoint of the documents and signing off on section 2 to somebody else, that can stand in your shoes and sign for you. And you as the employer are going to be liable for any issues on the form for that individual, but it doesn't necessarily have to be an employee of the employer who's doing section 2. So, kind of like if I'm hiring somebody and they are, kind of based in Texas, and it's going to be fully remote, like I'm probably not flying to Texas. Like they might be coming here for onboarding, and that's a good chance to get it done. Alternatively, to hit that, kind of that 3-day deadline, I'd send the form in advance to my employees, say like, get this done by, kind of day 1. And then it's kind of like a lot of times it ends up being like on the employee to find somebody to do section 2. And it's really interesting because there's no requirement in terms of who it has to be. It can be a friend or family member. A best practice is to try to avoid friend or family member situations, because you're, kind of like, I don't know, you're kind of in a situation that if somebody's going to be untruthful in the form, it's more likely that, a family member would, kind of support that, or, kind of look the other way if the documentation has looked weird. If you had somebody who was going to be high risk anyway. The hard thing is like, all right, like then who? You kind of like, a lot of employers over the years have said go to a notary, because you're just like, I don't know, like notaries, they deal with paperwork, and a lot of notaries will, it's still a good option. You don't have to have the form notarized. But in California, for example, it's not acceptable for notaries under their roles to do I-9s. And kind of increasingly people are pushing back, because they're just like, I don't know, this is not my deal. Like, why am I signing under penalty of perjury? Like, this is not my employer. Like, I don't really want to do it. Like who should we do it? So it's still going to be an option. And if you having it done by like, kind of a neighbor, if you in the absence of any other option is better than no form. So, kind of it's going to continue to be a really important tool for employers to use in terms of using an authorized rep, especially for remote hires. And especially if you don't have a lot of remote hires, you're kind of like doing a one-off and just trying to make it work. But, a best practice for that is like, yeah, but then get the original form back and, kind of review it in real time. And if there are any errors that need to be made, like nip them in the bud, make sure it looks good, because you want as the employer to be kind of like checking, controlling it. Because again, like your technology, like it's the employer's deal on these forms, and it's not going to be an excuse to be like, oh yeah, well, their neighbor didn't do a good job. It's ultimately going to be the employer. So we have a little under a half hour left. We're going to talk about E-Verify and then kind of like cover some hot topics. So far we've talked about the electronic I-9s. We've talked about the alternate virtual review, and it's goofy because it's like it all feels electronic, right? Like it's all like on the screen, like it's kind of exhausting. The different variations. Like, are we ever going to get to a system that is just like all integrated, like in the government, that we drop the forms? Like, let's talk about E-Verify Plus. That's kind of coming. So what is E-Verify now? So E-Verify is kind of like the in many cases, like voluntary optional like online companion to the Form I-9. So if you are doing your, kind of like verification practices, if you're enrolled in E-Verify, you are not able to skip the actual I-9 process. It's still a legally, kind of like mandated step to do the I-9. You use that I-9 information to do E-Verify. So if there's anybody on this call that is like doing E-Verify and like does not have I-9s because they're in E-Verify or anything like that, like, like big red flag, E-Verify, you do not, for E-Verify or E-Verify Plus, you do not skirt the I-9 obligations. As of right now, you still have to do the I-9 form. E-Verify, kind of was the progeny of a basic pilot program that goes back, kind of quite some time now. And what it is now is an online system where there's an enrollment. So an employer would enroll in E-Verify, and as part of that program, they sign a memorandum of understanding. And it's basically a double check of the information available in the I-9. So you do the I-9, and then the employer goes into the E-Verify system and creates a case and enters the information from the I-9 into the system. And that information is then run into the E-Verify database, which checks the Social Security Administration and Department of Homeland Security databases and compares it with their records. So, kind of you're basically like verifying the information. So if I do the form and the I-9 in section 1 asks for a Social Security number. So if I do the form and I'm an E-Verify employer, I need to require my employees to populate that field for the Social Security number, because I need to have it to run the E-Verify program, and my employees are going to be checked against the Social Security Administration database. If I am not an E-Verify employer, the Social Security number field in section 1 of the Form I-9 is optional, and I cannot require my employees to populate it for the Form I-9 section 1. And you just want to be thoughtful around that, because you're probably thinking like, well, yeah, that's fine, but I need it for the tax stuff. Like, like it's like that's a stupid distinction. Like I need to get the Social Security number anyway. And I hear you, and I kind of agree. What I would just say is, like, if you're not in E-Verify and you are asking for the Social Security number, do it after you've completed the I-9 and you say like, okay, here we are, we're, kind of like, we've done the I-9 process. Now we're moving on to you, making your tax elections, please provide your Social Security number for that. That's the, kind of the talk point on that. But, you need it for the Verify process, because they check the Social Security Administration database. And if there is some type of kind of like hit, like, so if there's a non-confirmation, so if you take my information and you put it in and it doesn't come back, kind of like, most of the time it comes back just like confirmed, relatively quickly. Sometimes there's an issue with either the information on the form in either the DHS or the Social Security Administration database, or both, and that comes back as a tentative non-confirmation. They like, it comes back to the employer, and the employer has to then go to the employee and say like, okay, like this came back, are you going to contest it or not? And then the employee could say like, nope, see ya, like I'm out. And then you're like, okay, like, say like employee did not contest, and then it gives a final non-confirmation, and then that's just kind of done. And you're not employing that employee. Many times it's just an error. There's something like, kind of like a name didn't get updated when a woman got married, something like, there was some type of issue in the database, and you go back and you say to the employee like, oh, we got this notice. Are you going to contest it? And then the employee says, yes. And then you say, like, okay, you enter in the E-Verify program, like employee is going to contest it. And then the process moves to the employee to go through certain steps and certain timelines that are communicated within the system to follow up and then try to fix it. Sometimes it's fixed fast, sometimes it might take a little while. As long as everybody's doing their thing, then the employee continues to work, and the employer is not allowed to take any adverse action on the employment relating to this issue. So if I say like, I don't know, like I don't think they updated it when I got married, and then you're like, I'm going to go try to fix it. As long as I hit my timelines, I do my stuff, you can't fire me, because I had this non-confirmation. So the idea is to allow you to kind of check your workforce against the system, and the memorandum of understanding kind of controls the terms and conditions for which you are allowed to use the E-Verify program. And when I say that, a couple of questions in the chat relate to like, all right, who do we use E-Verify for? We use E-Verify for our new hires. So we are not allowed to use E-Verify to like test the employment authorization of somebody, who hasn't done a 9-9. I can't take your information and like enter it into the system just to like make sure you clear. Like that's not allowed as the employer. And you don't run your current employees through the system that were not, kind of part of this like, kind of onboarding process when you were in E-Verify, under those conditions. So you use it for new hires only. E-Verify is voluntary in most cases. However, it is required in certain cases, and it is mandatory if employers have certain contracts with the federal government. So if you have a contract with the federal government called the FAR E-Verify clause, then you are required to use E-Verify. You're kind of like in a separate bucket within the system as a federal contractor. And then in those cases, you would possibly use E-Verify for current employees. When you enter into the contract and you're enrolling, there's an opportunity to kind of like do it for everybody. Or, kind of if you have current employees that are going to be assigned to the contract, then you would put them through E-Verify at the point they are assigned to the contract. But that's going to be really specific to the kind of like the contract, the timing, like all of those things. There are also certain states, and even like smaller counties, cities, municipalities that have required E-Verify use. So depending on where your company is based, you might be required as part of a, kind of a state or local law to use E-Verify. And, when I started to, track this, you're probably thinking like, what a weirdo. Like, what is she so into this? But I can tell you that I graduated law school in 2007, and it was like, kind of right around the time that there was a recession. A lot of it was like, all right, like, kind of like all lawyers have to have like some type of like subject matter expertise. Like, what are you doing? What are you tracking? And one thing that I thought was really interesting, back then as a young lawyer in kind of an emerging area was this, at that point, there was kind of more of a patchwork popping up of state E-Verify requirements. At that time in like the mid 2000s, like Arizona was doing laws, like Florida had just done, kind of a government order, like Florida's back in the mix, but like, kind of just like this idea that we were having like, kind of state by state requirements. And a lot of my clients have, kind of like locations and, kind of like workforces that are not just in Maine, but are national. So I started to kind of like track this, and, I just think it's very interesting. But I will say that a lot of employers that have, kind of multi-jurisdiction locations might elect to get E-Verify so that they, kind of like just like as a company do this across the board and don't have to be like, oh, where is this person being hired? Like what are we doing? And, kind of like all of that. So, there are, federal contractors are required, there are conditions and requirements based on certain local laws. There are some things you might want to do, and you might have to be an E-Verify employer to do them, kind of in an incentive-based program. So we talked about the alternate document review, that's a condition. You have to be in E-Verify, you have to be in good standing. You also, kind of if you want to hire certain students and extend their status, then you have to be be enrolled in E-Verify. So there are like some, kind of carrot stick approaches too that might make sense for employers to be in the program. Sometimes you might have a contract with a company that says like, I want my subcontractors to be in E-Verify, and there are too, kind of like if you're doing a merger and acquisition, there are opportunities where you're looking at your verification and compliance. And if you're, kind of bringing on employees of a company you've acquired, it's going to depend on the facts of, do you do a new I-9? Do you use E-Verify? You sometimes like the opportunity to do that is at the point that they are coming onto your workforce. If you're succeeding to the interests and the liabilities of a prior employer, you then in that situation may elect to do new forms, in which case, kind of you'd be looking at thinking about that, or, kind of like just bring the I-9s over, kind of and then you're, kind of liable for any omissions, and that the E-Verify considerations and the processes are kind of like mixed into that. But typically that decision point is occurring, kind of at the point that the acquisition closes. So there's a question in the chat about kind of like, what do we do with prior employers? It's probably going to be fact specific, as how that kind of that shook out. And, kind of in terms of hot topics and what you should be thinking about, if you're in E-Verify or not being in E-Verify. So E-Verify has different like methods of access. So one of them is, kind of direct user access. So I am an employer and I have signed up for E-Verify and I do the I-9, and then I, kind of like complete the E-Verify process, and it has to be done on the same timeline. So your E-Verify process has to be done within 3 business days, after the date of hire. There are also, kind of like the different like, web service E-Verify users, and that's basically the model that, I have an electronic I-9 system, which also offers E-Verify integration. So as part of that system, I'm doing the process in a vendor system, and then that vendor is a web service user, and we have a different memorandum of understanding, and they are, kind of feeding the information into E-Verify, and that process flow looks different. It's kind of like taking that step, like, kind of like off my immediate task list. But I think, one thing that all employers should, kind of like keep in mind, and I really encourage, kind of like employers that are using electronic vendors and might have them doing the E-Verify to just kind of like take a step back and think about it, and kind of just keep in mind that when you are, kind of like entering into those agreements, are not like entirely outsourcing the E-Verify process. There are pieces of the process that the employer is going to be still involved with, including following up, with employees if there's an issue and they have to do any further, kind of like communications. But also there are, kind of pieces of E-Verify compliance that require you to be trained, kind of like users need to be trained. You have to be like, kind of like in certain like, kind of like trainings for the alternate I-9, like just on an ongoing basis. And when you sign up for E-Verify, you also designate hiring sites. If you think back to the slide that we talked about, the alternate review, you have to be enrolled in E-Verify at the hiring site where you're hiring people. So you have some control in the E-Verify program that like, if you're a multi-state employer, you can sign up to just use E-Verify at certain locations. You don't have to do all, but you want to just like kind of think about like, okay, like, all right, like when did I sign up for E-Verify? How big was our company? Like what did I put for the hiring sites? Are we using E-Verify for people that are hired at different locations? Are we not? Like, should I be dropping it? Like, so I think like I would very strongly encourage everybody as a takeaway, to kind of like be proactive around, kind of like managing, owning, like did the person who signed up for E-Verify like, 5 years ago quit? Like who owns the account? Like who knows this stuff? Like, kind of like it's an opportunity, especially if you're not having any issues, to take a step back and be like, all right, like what are we doing in the system? Do we have a good handle on like what our registration looks like? Who has access to it? Have we done trainings? Like, and are we communicating with our web service provider too around expectations, compliance, all of those things too? Because again, at the end of the day, the employer is going to be liable for like all of this stuff, and to be like, ooh, I thought the web service had a taking user, like, or web service user had it taken care of, is not ultimately going to win the day. And it's something that I think is just really important, because again, kind of like, we don't know what an E-Verify user of good standing is. We don't want to be kind of caught flat-footed and like, kind of like be backing into this defensive position to be like, no, we're okay. Like, like let's be proactive. I'm getting a little bit over dramatic. Like, let's seize the day. All right, let's take a look at how we're enrolled if we are E-Verify employers. So we've got, we covered a lot of these things. One thing that's really interesting, and this is going to be a topic of our next presentation on this whole, like, kind of like, managing, kind of foreign workers. There are a lot of workers that are in the United States now that are here in temporary status, and their, kind of their status and the duration, kind of may be impacted by actions that are being taken to kind of modify their status through the duration by the Trump administration. So if you're seeing it kind of like in the news that like, oh, like temporary protected status was shortened for this country, but there's litigation, or individuals who were permitted to come into the United States work authorized that were, kind of or it's called paroled in and given work authorization, that the government is sending them notices that basically say like, no more, like, kind of like you're done, time to go. Very interestingly, the government is starting to post, kind of like within the case alert section in E-Verify information when particular employees have status that's been impacted from these. And that provides this kind of like backdoor method to provide, notice and arguably knowledge to employers that might trigger re-verification requirements. So, we kind of opened with this idea of kind of like you re-verify when you have knowledge you need to do it, kind of like at one end of the spectrum is like, yeah, they gave me an employment authorization document card that has an expiration date in the future. Like, I'm going to set a reminder, I'm going to do that. Like, there's like a whole other, kind of like, kind of like spectrum of like when you could get knowledge and what action you might need to take. But like this whole idea of like having an employer enrolled in E-Verify and like having E-Verify like posting alerts within it, like, opens up a different level of conversation. And I think possibly liability for the employer if they don't, kind of like take action to check in with that employee, if they get listed on the list of possibly needing to re-verify and it's outside of the, kind of the normal timeline. And it's wild. It's interesting because you don't use E-Verify at the point of re-verification. Like that's just an I-9 thing. So again, it's like E-Verify is used typically just at the point of hire. They do put kind of like notices like up if somebody needs to be re-verified as a courtesy reminder, but this is a different, kind of thing that's starting now. We're going to talk about that in the next section. And there are pros and cons, for being in E-Verify. I have a couple more slides, and if we have time and no other questions, we can do the, kind of, we can circle back on some of the pros and cons and stuff to think about. So E-Verify Plus, kind of like, is this the future? Kind of like we talked about, and kind of like I posed the question, like, well, I don't know, what is the future of the I-9? Like, are we going to get out from under this paper-based form? Like, is this like going to go to a fully integrated system? Like, why not? What should I be thinking about? So the government is like starting to kind of like prop up and like think about like what the future of the I-9 stuff is. And they have rolled out this like, what they call the next gen, the next generation of E-Verify, and they have named it E-Verify Plus. So, kind of like that's now an option. It's not an option for everybody to use E-Verify Plus. Right now, my understanding is it's still only available. It was like last summer it was piloted for like 10 employers. I think that if you are a direct E-Verify user, you do have the option to enroll in E-Verify Plus. And it's a different variation of the E-Verify program. And one of the things that the government touts as a, kind of an enhancement and a new consideration for E-Verify Plus is that it front loads the process with the employee, not the employer, so that the process is kicked off with the employee, and they log into E-Verify Plus. They get the kind of the process started. And if there is a non-confirmation notice, then it goes directly to the employee from E-Verify, and it takes the employer out of the middle of the process of having to see the notice of non-confirmation within the E-Verify system, get notice, communicate that to the employee, to ask the employee if they're gonna like, kind of challenge it or not, and then kind of like babysit that whole process. In E-Verify Plus, the control runs to the employee on that front end process. And then once they're confirmed, the process kind of shifts to the employer, so everything kind of like runs through, kind of that process there. I am very troubled. I like the idea that we are kind of like innovating and we're thinking about it. I am very troubled with the way E-Verify Plus is being rolled out in practice, because the communications, and I've watched their videos, I've sat through like some of their webinar trainings. I've looked at it, but they communicate around this E-Verify Plus. They say you can create the form electronically. Like there's a lot of like language about this being like, kind of like an electronic I-9, like what's the downside, like all of that. And it is not clear, in the mix that the employee still needs to create an I-9 and needs to sign it, or, kind of like be using a system where they have the electronic signature option, that complies with everything. So I would say, kind of like, if you have the option to use E-Verify Plus and you want to do it, I think it's okay, but you just want to go through it like very careful around understanding what it is and what it is not presently. And at present, it is not an electronic I-9 option. You still need to create the form, but what happens is like the employee does the E-Verify program, and then they're populating stuff in the E-Verify Plus system that then like populates section 1, and then like, kind of like, then they're like, having to sign it, and then it goes through. But like, there's a very important and open question of like, okay, federal government, you rolled this out. What does your audit trail look like? Like if you're going to be like offering this, like, and you want employers to be in a position to be compliant, like, like how are you managing the audit trail? How do employers have access to it? Are you instructing employers to keep and download that audit trail and know what it is? And, so it's out there, and but like I said, it's not required, even if you're a mandatory E-Verify user. The plus side, and I don't disagree with it, is that it shifts the order of stuff, and the employee kind of like does their thing first. And I think this is, intended to be really kind of like the beginning of the end of the paper I-9, where you have a system where the employee is like logging in and they're kind of like verifying their stuff. And kind of like the language is kind of used, and I've heard the government saying kind of like contemplating how this is going to be rolled out and roll over, is that the employee is going to essentially get this like token that shows that they're work authorized, that could then be transferable to other employers. And like I think that's true to some extent. Like if I had an issue with my social and I went through E-Verify once and I went to them and they fixed it, then that should be one and done. It should be good in the system. If it's attached to me, like that's good. But that doesn't mean my next employer doesn't still need to do the I-9 with me. Like, even though I've kind of like got this like, kind of pre-clearance with the E-Verify program, which might, kind of avoid me needing to get, kind of through it again, I still need to do the form, and so does the employer. So it's a little bit confusing. So again, I'm just going to run through really quickly, kind of best practices that we talked about, whether you're in the paper or the electronic. Present the employee the instructions and list of acceptable documents. Like, don't just send them into an electronic system that you think is like, very convenient from a total HRIS system. If that, kind of introduction to the I-9 does not give them an opportunity to at least click on the link for the I-9 instructions. And very importantly, the list of acceptable documents that lives with the form itself right now on the PDF posted on the USCIS website. Make sure that they have that. Make sure that they understand that like the employer will take any acceptable documentation from the list. Again, the list of acceptable documents that you're giving to them is intended to be a guide, and essentially think of it as kind of a category of types of workers. It's not complete. It's not a finite list. There's other stuff that might be acceptable that falls into buckets, like the employment authorization document referenced in list C has a lot of stuff that, kind of like could qualify, and you don't want an employer, kind of like, not taking, kind of like a NAT certificate or something that would be acceptable. You don't want to over document, in paper or electronic. You want to kind of do the minimum, do your job. And then, when questions come up and all this stuff, like, track the hard copy form, like if something feels, no matter what system you're working in, electronic or paper, if you see something and it kind of feels weird because like you're familiar with what the paper form looks like go back to the paper form, push back on your vendor, and, maybe revert to paper so that you don't create any issues that wouldn't have one. And we are at 10:27. I will pause for a second to see if there's any burning questions, or if Katie or Mark have anything that they want to add before we transition.
Absolutely. So one of the things for everyone, as a sort of aside, you might see in the chat now, for the training that we talked about at the top of the hour, we put Mark's contact in there. It's M for Mark, Ellis, ELLIS @mainchamber.org if you're interested in that. So Katie, I'm going to maybe try to capture one of these questions. So Diane has mentioned that they acquired a company to use E-Verify paper I-9s. Are we okay to now E-Verify those employees?
It's going to depend, I think on all of the acquisition questions, like, how long ago did it happen? Was the I-9, kind of like, was the acquisition one where it was like, kind of like a stock or asset one? Like, did you acquire the liabilities? Like it's, kind of like, and even in the acquisition thing, like, it's just good to like, kind of do your audit and be like, all right, do we feel good? Like, even if you felt good about acquiring the I-9s in an acquisition, like you should still audit them because, you're going to be liable for any issues, whether kind of you always want to be very careful around e-verifying current employees, relating to it. So I think depending on how long ago that happened, like if you did new I-9s, if you acquired them, like it's going to be fact specific around the M&A stuff. It's, it's the guidance in, kind of like all of the M274 and the I-9 stuff is always just like, yeah, like, these are your options, but talk to a lawyer around it, partly because I don't think the people who wrote the M274 like had a really strong understanding of all of the like M&A stuff that could happen because it's hard. Like, like they're just like, it's fact specific, but again, I hate to punt on that too, but I would say like, I don't want to give a blanket answer in this because like you really are going to want to look at the, kind of kind of like the timeline that you have. It's hard to do all your I-9s within the 3-day period after an acquisition closes, and that just might not be a luxury you have. But kind of like a lot of employers have to plan around that and kind of put that on your M&A checklist. A lot of stuff is people are just like kind of like when you're doing an acquisition, the I-9s are like the least of anybody's concern. But now everybody who's been on this presentation, like they really they get it, they know it. So make sure that you're working with the company like on the front end to be thoughtful, and then kind of like take a look back and be like, okay, like how did this shake out? What should we be doing?
Awesome. So everyone who's listening, key takeaway, put that on your M&A checklist.
Yes.
So we are at the top of the hour. So just a few reminders for folks answering again. Yes, this is being recorded, as are all of the sessions in this 4-part series. So next week, we've got the webinar is Workers with Temporary Status. That's on Thursday, June 5th. If you registered for one, you have registered for all of them. So we look forward to seeing you next week. And thanks so much again to Katie for walking us through all of this. I would say after last week and this week, you have a much better sense of the I-9, both the basics and beyond the basics. So we look forward to seeing Katie, you next week, and everyone else back next week for the next part in this series. So thanks again.
Super. Thank you. Have a nice day. Thanks, everybody.